Namaskar. Hello and welcome to PGurus channel. I'm your host Sri Iyer. Today I have the pleasure of company of Sri G Mohandas, who is an engineer, is an entrepreneur, is a TV personality, he's a lawyer and an author. And he would like to weigh in on the recent Supreme Court ruling that anyone under Section 124, also called as 124A, I should say, also called as sedition law, that until the government clears or states its position clearly that no new FIRs be filed. So let us take a quick look at what is this 156-year-old law called sedition law. Is it outdated? Are there any other alternatives? Everything that we would like to know, Mr. Mohandas ji will lay bare the facts and figures. So Mohandas ji, namaskaram and welcome to PGurus channel, sir.
Namaskaram. Happy to see you again.
Likewise, sir. Mohandas ji, what do you make of this current stay on having anyone file FIRs under the sedition law? I know this is a 156-year-old law coming from British age. What do you make of it? Do you think that UAPA has enough teeth so that the government can just say this is an old law, we just scrap it, and if you have to be charged someone, if someone has to be charged, then just charge them under UAPA? Would that be a one-for-one comparison, sir?
No, this is a bizarre joke by the Supreme Court, I must say. See, Supreme Court went into the constitutionality of Section 124A of IPC way back in 1962. A 5-judge bench that is called Kedarnath Singh versus Union of India. This constitutionality of 124A was challenged, and 124A was upheld by a 5-judge bench in 1962. Now, if you want to make any further correction on that, or you want to freeze it at least temporarily, you must have at least a 7-judge bench. That is according to Supreme Court rules as well as precedent. Therefore, whatever Supreme Court said today is ex facie patently illegal. I am sorry that I have to make this comment about the present Chief Justice also. If you go through the order, you read the order, they are very clever. It's not an order at all. What is that the Chief Justice has written? He is saying that we hope and expect that Government of India and state governments would freeze actions which are already underway on Section 124A, and they will not file any future FIRs on this section until the Government of India considers the matter and comes with a proposal. Now, hoping and expecting is not an order. Supreme Court has to be very clear that we hereby direct or we declare that Section 124A is unconstitutional, or we are seized of the matter until we go into the detail and give a final judgment. No 124A proceedings in this country shall take place. Even the present cases shall, there will be an embargo on the present cases, and future cases also. Section 124A is not to be charged until unless with the specific permission of this court. This is the order. This has to be the order. It is not that we hope and we expect that Government of India and the state governments at their mercy may decide appropriately. Is it an order from Supreme Court? I don't know. Because why did Supreme Court has to some sort of use this malleable and ductile words, because there is a constituent bench judgment, constitutional bench judgment in 1962, which the judges know they cannot surpass. There are only 3. You have to have 7 people to touch that judgment. Therefore, instead of directing somebody, you say that we hope and expect, etc. And everybody is celebrating. All anti-nationals, Everybody who is afraid of 124A is celebrating, saying that it is a landmark judgment. That is, it's not a judgment at all. It is not a judgment. It is a hope and expectation. That's all. What is that the Supreme Court is doing? This is what probably once Arun Jaitley said, the the tyranny of the unelected. I think this was the word he used.
Yes, yes.
This
yes.
is a bizarre tyranny of the unelected people sitting in Supreme Court. They feel they are not accountable to anybody, and they can use words at their whims and fancy. See, Constitution under Article 141 and 142 has given enormous power to the Supreme Court, and power with responsibility also. Now, Supreme Court is, for the past few days, they have reduced themselves into municipal court. Supposing a municipality is coming and demolishing your compound wall, you have to go to the municipal to get an injunction for non-demolishing. This type of injunctions were given by Supreme Court for the past several days. अरे यहाँ demolition हो रहा है, okay, stay order दे दो. वहाँ हो रहा है, okay, stay order दे दो. What is this? This type of stay orders, injunctions are to be given by municipals. And then what for municipal is there? Or is there no municipal in this country, so that everything is decided by Chief Justice of India? Why high courts, section court, magistrate courts and municipal courts? I don't understand. In fact, these judges are making a mockery of justice in India. I should say that.
One question, Mohandas ji.
Yeah.
Whenever such small petty things come to the Supreme Court, should they not direct the applicant to go to the appropriate, and say, go to the municipal court? Why are you coming here? Why are they wasting their time giving these stay orders?
Yes, recently there was a news that one poor man approached the Supreme Court saying that his daughter was raped and murdered, and the case is pending in the magistrate court for past 10 years or 14 years. It's not proceeding for various reasons. So he needed a direction from the Supreme Court, asking the magistrate to complete the procedure within a stipulated time. Then Supreme Court got angry and they said, don't flood this court with this type of petitions. Please go to High Court. That fellow was driven out. You know, very serious thing, rape and murder. And that too, pending case for 10 years or 12 years. Justice could have been done to that man, but it was not done. But high and mighty, political high and mighty, and people belong to certain ecosystem. If they go and raise a small petty issue, immediately that becomes a constitutional issue. Stay order is issued. Government of India is asked to file an affidavit in the afternoon itself, so that before 5 o'clock we will issue an order. And of course, 5 o'clock we want to go home, unless there is an application for some, some terrorist who is going to be hanged. He will be able to open the Supreme Court in the midnight. Otherwise not. For genuine people, the Supreme Court is closed at 5 p.m., practically at 4 p.m. After that, no business will be done. All these things are there. What is happening in our country? You know, 124A is very simple. Anybody can read IPC. It is not a draconian law. Nothing like that. You see, the biggest ever booking under 124A was done by Jayalalitha during the Kudangulam agitation. Now, Kudangulam, the Tamil Nadu people, rightly or wrongly, they were agitating against that. And Jayalalitha filed 6,000 FIRs under section 124. Even a Dalit singer, he was a street singer, he was also booked under 124A because he objected to Kudangulam atomic project. In fact, that fellow doesn't know what is atomic project. There was a big hue and cry. He also joined for fun. And he was also booked under 124A. Where were all these people? Now today, Kapil Sibbal submitted that 13,000 FIRs have been filed under 124A. Out of which 6,000 were filed by his own ally. When UPA government was in power, Jayalalitha did all these things. Now, for chanting Hanuman Chalisa, they have taken a case under 124A. There is no 124A, no sedition at all. But still, Uddhav Thackeray ordered that 124A shall be charged. And who is supporting Uddhav Thackeray? Very Kapil Sibbal is supporting. And he is arguing against 124A in Supreme Court. And the court is silent. Court should have asked him, why, you are a senior politician also. You are a senior lawyer, but you are a senior politician also. What is happening in Maharashtra? Why did you charge 124A for Hanuman Chalisa? Merely because it was chanted in front of Chief Minister's residence? Such nonsense is going on. A big campaign has been unleashed by anti-national forces for celebrating that Supreme Court has taken out 124A. Nothing has happened. Tomorrow, if boldly Government of India says that, very sorry, your lordships, we cannot satisfy your hope and expectation. Please constitute a 7-judge bench and let us go into the merits of 124A. Till that time, 124 will play in this country. If they make a submission, you will see the judges will be in quandary. They cannot answer that question. You cannot just give a go by the constitutional procedures. There are procedures, not only law, there are rules and procedures, how a court must function, how police should arrest somebody, how 124A, under what circumstances they have to apply. If it is wrongly applied, there is a sessions court, he will immediately give bail. You know, the largest ever misused section in India is section 295A. That is creating, what is that? Attacking a religion or deriding a religion, criticizing a religion. But what is wrong in criticizing a religion? That 295A is required by Islam, not by Christians or Hindus. We don't have a problem. Hindus, neither Christians. They don't worry about who is criticizing Bible or Bhagavad Gita. But Islam is worried about who is criticizing Quran. Therefore, 295A is intact. And there is a petition filed, public interest litigation filed by Dr. Sabrimala Swamy. It is pending in Supreme Court on this 295A. That is the biggest ever misused section of IPC. Nobody is touching that because nobody will touch Islam or Islamic fundamentalism. Everybody will sing peace for them. Now, 124A is concerning the country's security, sedition. Okay. But country is below religion. That is why 295A, nobody will touch. 124A, everybody want to touch because everybody can play with India. That is the thing. And you see, there are two exceptions in 124A. It is clearly said that comments expressing disapprobation of the measures of the government with a view to obtain their alteration by lawful means without exciting or attempting to excite hatred, contempt, or disaffection do not constitute offense under this section. You can criticize the government, you can agitate against the government, you can raise slogans against the government. Only thing is that you should not incite violence by take guns and kill this Indian administration. This is India, let us kill them. This type of speech will come under 124A. Otherwise, every agitation would have come under 124A. Every agitation is against government, either state or central, but it is not coming. So the so-called misuse is a very small abuse by few authorities. Some policemen might have played mischief, some politicians might have played mischief. That doesn't mean that you take out and cancel an important section. And the exception number 2, comments expressing disapprobation of the administrative or other actions of the government without exciting or attempting to excite hatred, contempt, or disaffection do not constitute an offense under this section. So, exception to criticizing the government and exception to criticize the administrative steps. If people want more wages, they are on the streets demanding more wages. Is it not an agitation against the state? Definitely. It is an agitation against the state. But 124A says that it is an exception, you can do that. Because it is an administrative decision. Administration decided that only 1,000 rupees is to be given to Mohandas. Mohandas is shouting that, no, I need 1,500 rupees. This is a legitimate demand. And Mohandas is making big speeches that injustice is being done against me. See, how will I live with 1,000 rupees, etc., etc. All these things are legitimate. That is why agitations are taking place, including the so-called CAA agitation, the Kisan agitation. Every nonsense was taking place when 124A was intact. How many people were booked under 124A? If 124A is being used against Islamic terrorists and their conduits and their support base in India, the moment the government started attacking them with this section, they have created an atmosphere that there is a big danger looming on citizens' head in the name of 124A, and therefore it is to be declared unconstitutional. And Mark, the advocate, and the senior Congress leader, Kapil Sibbal, he is #1 anti-national. You know, the last case he appeared was for Siddiq Kapil. He is in Mathura jail now for the past 1 year. The moment Kapan was arrested, Kapil Sibbal appeared in Supreme Court for him. Now, for any arrest, you have to go to either to the magistrate or to the Sessions Court. You cannot directly go to Supreme Court. He went with a habeas corpus petition, and the petitioner was Kerala Union of Working Journalists. I inquired from where did they get the money to pay Kapil Sibbal. Either Popular Front has paid money to Kapil Sibbal, or Kapil Sibbal has voluntarily, pro bono, done this case. In both cases, he has to explain why he did that. Either he has to show the source of the money, he can wash off his hands saying that, I don't know, I got the money. He can declare that. Let him declare that. Or he must say that I love Popular Front too much that I am fighting their case free of cost. And the very same Kapil Sibbal today is in Supreme Court arguing that 124A is unconstitutional. How many times this Kapil Sibbal himself was law minister in UPA? I don't know how many times, I didn't count. But he was law minister. He could have removed this, repealed this. UPA could have done that. Why it was not done? Chidambaram was home minister, now speaking against 124A. All these were ministers. They didn't do that. And now they are shouting in Supreme Court, and Supreme Court is yielding to their request. Nobody is asking the basic question. If I was the judge, I would have been asking the question to Kapil Sibbal, why you were the law minister, why you did not do that? You were law minister just 80 years back. Itna nahi ki 1,500 years back. You were there sitting in the chair. You could have done that. You did not. Nobody did. There is a communist government in Kerala. How many UAPA and 124A cases they have charged without any demur when it comes to Naxalites or Maoists? They are using these sections. And unnecessarily shouting on Modi. We must also understand, Sri Iyerji, that government of India doesn't have any police except in Delhi. In all other states, it is the state government which have the law and order machinery in their hands. Whatever FIRs are registered are to be answered by state government. Okay, if you want to blame BJP, you can say BJP ruled governments did this much. What about other governments? Biju Janata Dal government, this Telangana government, Simandra government, Tamil Nadu government, Kerala government. ये भी सब government है, Maharashtra government. They are answerable because they are the people who are registering FIR. Modi cannot register. Modi's hands are tied. Law and order is not in his hand. If there is an explosion and if the state police informs the NIA, then NIA comes into picture. With state government's permission, only CBI can take up a case. What are we talking about? All is state responsibility. Law and order clearly falls within the realm of the state. And if false FIR has been filed on 124A, then let Kapil Sibbal answer. How many cases have been filed by Rajasthan government? You should say that. How many by Punjab? I see, creating an atmosphere in this country has become too easy because the ecosystem is still with them, not with us. With us, I mean nationalists, and them, I mean anti-nationals. That is why you might remember a dialogue in Kashmir Files that गवर्नमेंट उनका है, ठीक है, लेकिन सिस्टम हमारा हाथ में है ना. This is the question Pallavi Joshi is asking. You remember?
Right.
So this is the system.
Very powerful dialogues. Yeah.
This is the system which is demonstrating its power against Union of India. That is our dear Bharat. All these anti-national activities are now coming up glaringly open. I don't know how the government is going to react tomorrow, because the wordings of the order is not at all an order. It is only an hope and expectation. That is all.
So here is how the government has reacted. I'll just show it to you. Kiren Rijiju, the minister, has said that empty words by Rahul Gandhi. So he's taking Rahul Gandhi to task because he says that the INC has done the same thing. And can you scroll down, please? And the history tells us that it is the Congress that is more guilty than the BJP. In fact, BJP has hardly done any misuse of this, I don't think. BJP tends to be more like, live and let live. How do you see this thing proceeding further, Mohandas ji?
No, this could be a political statement by Kiren Rijiju. That is okay. There will always be politics over this issue. How much I did, how much you did, etc. But thing is that whether our country is supposed to be safe or not, can you throw open all your doors so that anybody can abuse the country, anything can be said, anything can be hurled against the country? Now people tell me that look at America, they have their First Amendment, there is freedom of expression. I said, I don't want to look at America. We are a wounded civilization. America has done so many rights and wrongs, and their legal system is entirely different from India. Don't compare us with America. When it is convenient for you to imitate America, you will catch America. Otherwise, you will go to China. Then you will go to Japan. I said, why Japan cannot be a model? Is it not a successful country? What is the sedition law in Japan? Do anybody know in India about the sedition law in Japan? Absolutely unaware. Everybody is looking at America because America is permitting burning of flags. Now we know there are people in India who are waiting to burn Indian flag. That is why they are taking example of America. All these jihadis, they are waiting to burn flags. You make this type of judgments, this type of atmosphere created by Supreme Court will invariably lead to burning of flags throughout India. It is some sort of encouragement that you can do whatever you want with this nation, and nobody is there to question. We are here to protect you. This message has gone through the action of the Supreme Court. I will not still call it an order. It is not an order. It is a hope and expectation. Any government can say that, no, sorry, your lordships, we cannot live up to your expectations because we are responsible for the country. We are elected by people. You are nominated by yourselves. You have nominated yourselves. That is what is happening in Supreme Court and High Court. So they cannot claim that they are the repository of wisdom. I respect them for their legal knowledge, etc. But I cannot be a lesser nationalist than the Chief Justice of India. Vice versa is also not true. I am not saying that he is not anti-national. But the Chief Justice of India, I don't know for whose pleasure he did this thing. And what an order he has passed. It is not an order at all. Let him constitute a seven-judge bench and then go into the constitutionality if you want. there was some sort of impasse due to Sabrimala problem. What was done? It was sent to a 9-judge bench. Okay, that bench is not constituted. Subsequently, it's a different issue. Why it was sent to 9-judge bench? Because they have to examine a 7-judge bench in Shirur Mat. There is a judgment. It was a 7-judge bench way back in 1952. So if you want to touch that principle, you have to have a 9-judge bench. That is why Sabrimala issue was sent to 9-judge bench. Now, if our respected Chief Justice want to go into the constitutionality of 124A, please go form a 7-judge bench at least, and then examine constitutionality. Let the law carry on, take its own course, and finally, when your judgment comes, then you can say, this is what we have found, and that becomes the law of the land. Before that, freezing a criminal section of IPC is unprecedented in India, not only in India, throughout the world. You go into the merit and decide either way, not that you keep it in the freezer. Now, you see, tomorrow an allegation may come. I don't know. It may come that Chief Justice wanted to rescue few people from this 124A, and immediately the stay was lifted. This would have been, this could be an allegation which is coming against Chief Justice. See the dimensions of such judgments. I don't know. That is why I said I am so sad that it is a bizarre joke on the legal system, which Supreme Court did today. Thank you.
Thank you very much, Mohandas ji. There's only a few questions, so let's take the first question, please. Ragsyboy wants to know, how do we develop a pro-BJP ecosystem to counter this left liberal ecosystem? How do we rally the population to counter anti-India protests?
You ask this question to JP Nadda or people like him, how to create a BJP, pro-BJP ecosystem. I'm not a spokesperson of BJP. I cannot comment on that. It is inappropriate for me to comment on that. Because if I make a comment, that will look as if I am patronizing BJP. It's not good. So I'll not enter into that area.
Soni Singh wants to know, judiciary needs to be reformed. Why this soft approach to people who always speak against the nation?
Now, see, people forget because their memory is short. There was a National Judicial Appointment Commission Act passed by Narendra Modi government, the first term of Narendra Modi government, with the cooperation of Congress also, because it is a constitutional amendment, taking out this judge appointing judge formula.
Presidium, yeah.
It was passed in Lok Sabha and then Rajya Sabha with 2/3 majority, with the cooperation of Congress and opposition parties also. And then it was ratified by 16 assemblies, because you need ratification of at least 9 assemblies as per law. Modi took into confidence 16 assemblies. उसके बाद में छोड़ दिया, भाई 9 चाहिए, अब 16 है, अब बंद करो. And the act came into picture, and somebody challenged it in the Supreme Court. And Supreme Court, a constitutional bench, decided that it is unconstitutional. That too, 3:2 judgment. 2 judges said this arrangement is okay. 3 said this is not okay. This is anti-constitutional. So the whole parliament, Lok Sabha and Rajya Sabha, and 16 states were just dismissed by 3 unelected gentlemen of Supreme Court.
But Mohandas ji, the government could have still gone ahead and passed it into law, isn't it?
No, they passed the law. But according to our constitution, if a law passed by the government, the Supreme Court can test it against the constitution and declare that it is unconstitutional. And therefore, we held null and void. There was a standoff between, still the standoff is going on.
Could the government then force it to a 7-judge bench?
No, there is no legal position. There is no legal remedy like that. once it is decided by a constitutional bench of minimum 5 judges, you cannot agitate it. You can agitate it at least after 10 years or 15 years when the situation changes, having so many data with you, and then you can again say that now let us have a relook on that. That is how this Sabrimala happened. You know what Parasharan argued on behalf of devotees at that time. He was not arguing whether entry should be given or not. He was only arguing that why it should be reconsidered. Because entry is a secondary thing. If it is to be reconsidered, then only the entry question comes. So for reconsideration, he was bringing all these things. Finally, they decided, okay, whether to reconsider or not will be sent to a 9-judge bench. This is the procedure there. So a 1954 judgment is sent practically along with other issues. It is sent to a 9-judge bench in 2019. So kitne saal ho gaye? So you can agitate the issue, but after so many years, not immediately. You cannot see 7 bench is not an appellate bench of 5 judges. It's not appellate. It depends on if you want to reconsider something which was earlier decided by 5, you have to have 7. Earlier decided by 7, you need to have 9. Earlier decided by 9, for overruling that you need 11 judges. You know the famous or infamous case, PMI case of private colleges. That was decided by 13 judge benches. Keshavananda Bharati case, there were 13 judges who were listening to that. And Keshavananda Bharati case, the final judgment came 6-7. 6 judges were against and 7 judges were for. And people celebrate Keshavananda Bharati as a landmark judgment with just one judge tilting the balance, just one judge. Anyway, that is another thing. So let us not have the illusion that we can appeal against whatever Supreme Court has said. Supreme Court is the final court and there is no appellate authority or Supreme Court. That is how
Ragsyboy wants to know how was the Shah Bano case overruled then?
Yes, Shah Bano case was overruled by Rajiv Gandhi government by bringing a constitutional amendment. An order by Supreme Court can be overruled by Government of India through a 2/3 majority in Parliament, passing a bill against that. This was done several times. In fact, the first constitutional amendment was to circumvent the judgment of Ramesh Swamy versus State of Madras. At that time, it was not Tamil Nadu, it was Madras. That was the first amendment which Jawaharlal Nehru brought and several other amendments also. But when the court is giving an interim order, now what is that court has done today? They have not drafted an order. They said, we hope and expect, that is one defect. And it is an interim order. And they have put the responsibility of the time period on the government. They said, till the Government of India reconsiders and come with a proposal, we are freezing it. So what is that Government of India can do? Government of India can, at the best, they can do that tomorrow morning, go and tell the Supreme Court that we have examined once again. We don't think any change is needed in 124A. Now you please proceed. This could be one of the things. But that will be a grand or dirty fight between Government of India and judiciary, which Narendra Modi never does.
Now, Ramesh
so
Swamy,
I think we have to have.
Sorry. Yeah, sorry, go ahead, sir. Finish it. I thought you were done.
Yeah. So we have to have bit patience to see how things develop, how the states and Government of India reacts, because states also have a say. So what Supreme Court said that Government of India, along with state governments, so every state government will have their own opinion on 124A. That also is to be collected. So some time is going to go. In between, if some other development comes, then Supreme Court may wake up and vacate their words. There is nothing to vacate also. That is the play which I am blaming Supreme Court, that if it is an order, make it very clear and unequivocal. What is this? I hope and expect. I can also say that I hope and expect that Sri Iyer will pay me 10 crores tomorrow morning. But what hope and expect? Sri Iyer says that, very sorry, Mohandas, I don't have that kind of money with me. Bas gaya kaam se. So this type of word should not be used by. I have seen so many judgments in this type of words when they pontificate on an issue. They decide on an issue. Somebody wanted to hang G Mohandas. Then they decide that no, Mohandas is innocent and he should be let scot-free. And then they give some certain principle. We must have some humanity. We hope and expect that the Kerala police will have some more humane nature inbuilt in them, etc. We hope that the government will take such things very seriously. Murder cases should not be taken so lightly. We hope in the fair hope that the government will take appropriate steps. We are disposing this case. These are the areas where they can use expect and hope. Otherwise, a judgment has to be very precise and legal. Do this or don't do this. This is the content of a judgment. I hope that you will do it. What does it mean if the other man does not? Well, I don't understand what is happening in the Supreme Court.
Last question for the day. Ramesh Swamy wants to know, can this Supreme Court overreach be attributed to the indecisiveness and incompetence of this government?
That is too general a question. I would request Ramesh Swamy to make it specific. Too general a thing.
Okay, while he decides whether he wants to add on or do it or not, let's take a look at the next question. Udit Joshi wants to know, well, he's saying it is, Udit Joshi wants to know, is PMO giving armed weapon security or automated rifle plus 2,000 bullets to each army-trained Virat Hindu gun for 5 years, compulsory citizen short-term service, go back with your gun with pension? I don't know if there's not a question, it's just an observation. Never mind. So, Mohandas ji, I think that's the end of the session for today. Thank you so much, sir. This is a wishy-washy judgment. That's the best we can say. A lot of people are not happy with it, and some are rejoicing. And that is democracy for you. Obstreperous, noisy, pulling in different directions. Somehow we stumble forward. That's how I see it. Thank you very much, sir. And we'll be back again with such interesting hangouts. Mohandas ji is always a pleasure to have around. Thank you once again, sir, and namaskaram.
Namaskar.